Hello, everybody. Yes, I'm Andrew Jaloza from the Estate Planning and Elder Group here in Queens, New York, and welcome you to our episode 5 of the Queens to Cleveland Lawcast on estate planning. And with me today, as always, is
Matt Deliberato from the Deliberato Law Center in Cleveland, Ohio. It's hard to believe this is episode number 5 already. This is great.
yes, it is. It's really, and time goes by so quick with you because I have a great time doing these things.
Me too.
So, so today's episode, we're going to be talking about revocable living trusts. So, Matt,
Yes.
what is a revocable living trust?
Well, a revocable living trust is a legal arrangement in which an individual, known as the grantor, you can also call him a trustor or a settlor, transfers ownership of their assets into a trust. The grantor retains control of the assets during their lifetime, and they can revoke it or amend it at any time during their life. And upon the grantor's death, the assets in the trust are distributed to the beneficiaries named in the trust document. We always say, Andrew, that a trust is really just like a little red wagon, don't we? And
I
that
love that.
is, yeah, it's
Yes.
a great analogy. And it's just that it's a vehicle to place your assets to ensure who gets it when and how. And that's the core of estate planning.
Yeah, it really is the core of estate planning. And it also gives great flexibility and control over the assets that are in the revocable living trust. And I love it because we call it a little red wagon because when you think of a little red wagon, you think of it's an open box with wheels and a handle that you pull. If you think of all your assets like little gift wrap boxes, and you
Mhm.
take your boxes and put them in your little red wagon, fund them into your trust. Now, if something happens to you, either you become ill or you pass away, you don't have to deal with the things that you would have to deal with if you were carrying those assets per se. And so, therefore, the rules that you set up, that family rule book you create in your revocable living trust, would then instruct the trustee of what you want them to do if you are disabled or when you pass away. So all your rules are there. What's the main benefit from using a revocable living trust?
Well, there's several benefits, right? And one of the primary benefits is that it can help avoid probate. When a person dies, their assets typically go through probate, which is a legal process of distributing their assets according to their will, which we just talked about in our previous episode. Probate can be lengthy and costly process, as you've heard, and a revocable living trust can help avoid this process.
Yeah, that's true. Yeah, probate. So many people walk into my office says I need to avoid probate. I say, tell me more. Why do you need to avoid probate? They say, I don't know. Susie Orman on television tells me that, and I read it. I read it in the newspaper, and I see it on the internet. I'm not really sure. And so we talked about that in our last podcast, how intrusive,
Yeah.
expensive, frustrating the process may be. And the other thing about it is, what about privacy, right? That
Oh, yeah.
yeah, that's a big difference between and why we use a revocable trust versus a will plan is privacy, because when you file that will and create the probate process, that will and the process itself is now public in nature, and anybody can. They don't even have to go down to the courtroom anymore here in New York. How about in Cleveland? Is it on the website of the surrogates court in Cleveland like it is here in Queens?
Yes. Yes.
Yeah,
Absolutely. Totally searchable. And it's just uh, it's amazing to me how many people don't realize what probate involves and how that aspect of privacy is so important. We can look up Elvis, Prince, Michael Jackson. These are all people who didn't even have wills, and we can see how much comes into their estate and how much goes out of their estate. And another benefit is really just providing for incapacity, right? I mean,
right,
if the grantor
absolutely.
becomes incapacitated, the successor trustee named in the document can take over managing the assets.
That is correct.
And,
Yeah, and that's the nice
that's
thing. Will doesn't do anything for you, right? A will
no,
will
no,
does not get activated in your lifetime at all. It
no.
does give a plan for passing it on, and it's a fine document and it's a fine process if
Yep.
you don't mind if you have a simple situation. But I found that even in the most simple situations, I had two daughters that each were given 50% of their father's estate, and they both fought for 4 years almost to because they didn't believe the other one deserved 50% of the estate. So, like you said,
Right.
Michael Jackson and Prince, what you could also see is how much money goes out to the lawyers when you
Yes.
don't have a plan, right? You don't have a plan, or even if you have a will, there is a significant amounts of money that get paid, especially when there are contests to the will or unhappy potential beneficiaries and distributees who say they should have been thought of, or and so it can be an ongoing thing. The
Oh,
trust is also pretty flexible too,
oh
right?
yeah. Oh, absolutely. And to mention incapacity for the grantor, we should also mention incapacity and other issues that the beneficiaries deal with, right? We believe that you love your beneficiaries way too much to give them money. You love them enough to give them a trust. And that
Yeah.
is so important because it protects them from their divorce, creditors, lawsuits, incapacity, disability. I mean, just the list goes on all the things we can do in a trust. And so the beautiful thing about what we do is that we make sure that those beneficiaries get trusts. Whereas a lot of firms we see, they just give money outright. And that's just a shame. It's a waste of a document, in my opinion. Yes, it avoids probate, but boy, can you give protection to those kids? And that means so much. They don't get it right away, right? You won't understand this until we explain it to you. And that's why our workshops are so important. But think about it. If my kid gets a divorce, I don't want my ex son or daughter-in-law to get half of what I've given her, right? It's just that simple. That's just one example of how many can we give, Andrew, that are just reasons to give trust, not money.
Well, how about you give your son or daughter money and they're in a business with someone and they're about to be sued by their business partner,
Oh yeah. Yep.
or the things that they don't tell you about, right? Like, so if they
Right.
haven't paid their taxes in a while and the
Right.
IRS has a lien against them, when you give
Right.
the property to them outright, then the IRS is just, they've been waiting for money to come into that
Right.
social security number,
Right.
and
Right.
that's what will happen. And if we plan it properly, we can avoid that. Or, or,
Yes.
or, or just the fact of, what happens when you have a kid who spends $1 when you give him 50 cents, then you have that spendthrift that you really want to make sure they didn't squander a whole bunch of money.
Right. Right. Exactly.
And I guess lastly would be when you have someone who has special needs. If you have someone
Yes.
who has special needs, they're getting benefits from the government. And if you give them money or property that's more than $2,000, you may just destroy all the benefits they're getting, the thousands of dollars of benefits that help make their life livable.
Right.
So those are just some of the things that giving in a trust, that gift that keeps on giving.
Absolutely. Are there any downsides, Andrew, to having a revocable living trust?
Well, I think there are downsides to everything, Matt. I mean, the downside to, there's, the cost of setting up a trust is a little bit higher than it is for getting a will. But sometimes you have to pay more in advance and get the benefits later, because I know here in New York, we talk about somewhere between 3 and 10% of the gross value of the estate, depending upon how much fighting goes on, is a general cost of probating a will. And so, compared to that, the cost of preparing a revocable trust to avoid all of that was definitely a better thing.
Absolutely. And another consideration is that the assets in the trust are not protected from creditors. If the grantor incurs debt, creditors may still be able to go after the assets in the trust. And I've seen this happen. We're going to have another episode just strictly on irrevocable trust, but certainly a revocable living trust will not get you to creditor protection.
Yeah, that is a downside, because
Yeah.
you can't have everything, right? You can't have this
No.
open box and have all the flexibility and benefit and access to everything that's in that box and still get asset protection. And you're right. So when you're doing things like planning for long-term care issues and Medicaid, or you're dealing with protecting against creditors, a revocable trust is not the first option. But then again, neither is everything always suitable for everybody who comes into your office,
That's
right?
correct. Right, right. And that's why, again, I hate to be repetitive, but the workshop is so important. And it is really the beginning of the education of creating a good estate plan. We offer them, both of us do in our offices, and virtual, as I think you're all virtual, aren't you, Andrew?
I am completely virtual
Virtual.
still.
Yeah. And I have a lot of clients that'll just watch the recording, so they don't even need to come in on a specific time. But, it's imperative for you to have the education we can provide. And it's so imperative because I know that my clients understand what they've done and why they have done it. And that's so important. How many times do we have someone come in and say, I've got this trust, but I don't know why, right? They just have no clue as to why they have a trust. And
Or,
so,
or how it operates
or how
or
it
what they're
operates,
doing with it.
right?
So
Right,
I
exactly.
like the ones that come into my practice to have me take a look at the documents, and they've come to my workshop. They see what we talk about, and then
Yes.
they come into my office. One woman came in with these two wooden boxes, flunked them down on the table for her and her husband. It was $10,000 each for revocable trusts.
Oh
And
gosh.
I'm opening up the box and I'm looking at it and I'm looking for where is the schedule? What's in the trust?
Yeah.
And there was nothing in the trust.
Yeah.
They
Yeah.
paid basically $20,000 for two trusts that had nothing funded in them. And
Wow.
that's another different thing. The revocable trust, the downside of a revocable trust is if it's not properly funded, it's not going to give you the benefits you're looking for. Because
Correct.
if you think it's in the trust and it's not, more likely than not, it's going through probate. And if you don't have a will, now it's going through administration, and now the government will tell you not only what has to be done to pass it on to whomever else, it's going to tell you who you're going to pass it on to.
Yes, absolutely. And it's how many times do we see documents, not plans? And we believe in the fact that plans work, documents do not. And yes, you're going to have some homework. You're going to have to put some stuff into the trust, things we cannot do for you, like going to the bank, for example. But it's all in the end completely worth it. People always tell me, well, why do I want to do a revocable living trust? And the first thing I say is avoid probate. But the second thing, really, to me, is if your spouse passes, it makes it very simple for administration, right? Because everything's in the trust. Trust just continues. It makes life a lot easier than going to the bank and taking, my spouse off the account and, changing the house deed and doing all the things you have to do. It's already done. So you're doing some legwork up front, but you're really doing it for a purpose. And that purpose is to make it easier for those you love, period. Right?
Right, it makes it much easier because take for instance, you use a will, one of the spouse passes. You
Mm,
actually have to still go to court because you have to generally change, the executor, especially if you've appointed your surviving spouse, has to first have your kids sign off to go into probate. You
right,
have the whole family is involved in that process.
right.
Whereas you're
Yes,
right, it's a seamless, simple transition from from the two co-trustees to the one surviving trustee.
yes,
And plain and simple. No, fighting between the kids about signing papers or dealing with everything.
right. No, absolutely. So how does a revocable living trust differ from a will?
So a will is a document you create while you're alive. It names an executor. The executor is going to then be in charge of gathering your assets and passing them out. The will only controls what you own in your own name, and it must go through probate to then be authenticated by the court, authority given to the executor, and then only then will they be able to do something with the assets.
Wait,
The tr-
stop the presses. You mean you're telling me that a trust doesn't go through probate?
exactly. No
Oh,
matter which kind of trust
beautiful.
you use, it doesn't go through probate because what you have is you've now changed the ownership of property, made the trust the owner, controlled by the trustee who you've appointed, usually yourself and your spouse, and you just go on as if you were living your life before. There really is
Yeah.
no much of a difference except how maybe you sign your name. You
Right,
sign your
right.
name instead of Mr. Jones, it's Mr. Jones, trustee of the
Trustee.
Jones Family Trust.
Yeah, yeah. Very,
Yeah.
very simple stuff. People get confused. And I think that a confused mind says no. So our goal is to really not have you be confused. And one of the biggest things I hear, Andrew, is that, there is, what is this thing called a trust? Can I have a checking account? Is it a checking account? Is it a CD? And, I always say, no, a trust can own anything you can own, including real estate, bank accounts, investment accounts, right? Anything you think you own own a business, you can own in a trust. And so a trust can own anything you can own. So it really doesn't have any difference there. And by the way, you file taxes the same, right? There's no changing how you file taxes. There's no separate tax return for the trust. It's just using your social security number. So it's pretty simple and easy once you set up and get things funded to really administer this trust as nothing. It's really simple.
Right. And
No.
then upon the passing of either one or both, there's just the continuation of everything that was going on, as you pointed out. The
Right.
income continues to go to the beneficiaries from, property owned by the trust. The property doesn't have to be distributed out of the trust immediately. It can be used as the vehicle for the surviving or the successor trustees to continue to operate those things and to pass on the income to the family. And then when the property transfers ownership, it's a lot less onerous than having to go through the court's intervention, through the court's interaction to pass on property to whom ultimately will be entitled to it. And it's also a good vehicle, for doing things like avoiding capital gains tax, and also at the
Yeah.
same time, if necessary, providing for some estate tax planning in those states that have estate tax. Our state tax limits here in New York are pretty high. It's about $6 million a person, but there are still people who have that kind of money. There are lots of people who have that kind of money. As a percentage, it's probably a lot less than 1% of the entire population will pay estate tax here in New York. But the point is that there's ways of dealing with avoiding estate tax within the trust as well through some planning.
Yes, absolutely. So maybe as a recap, we can do some pros and cons. What do you say?
Sure. Well, the biggest pro, avoiding probate. The other
Yeah.
pro is keeping the control with the family and not with the government, right? You don't have to ask
Yes,
anybody for permission to do anything. All the rules are set down there. The trustee is supposed to do what they're supposed to do, and if they don't, there's provisions within that document say what happens about that too.
that's right. And privacy, again, as we talked
Yeah,
about, it's a private document and will not become public record.
unless you wanted to. The only way it
Well,
becomes
yeah,
public
that's
is
true.
if you tell people about it, right?
That's true.
There's no way to file it, which can be also a con in some level because
Yeah,
you have to depend upon the trustee to do what they're supposed to do. The
yeah,
beneficiaries are supposed to get what they're supposed to get. I've seen some
right.
situations where family members are overreaching and they do the wrong thing, but there's always the possibility for that, whether it's in a probate process or it's in, using a trust. There is recourse for that as well. The
Right.
trust is a little more expensive than getting a will, but I
Yes.
think the I think that the pros on that one outweigh the cons. Um,
Well, and I was just thinking of something, Andrew, and that is people ask all the time, well, what if I just put a beneficiary on something or I have a joint owner on my account? That avoids probate. And in Ohio, I don't think New York does, but we have a transfer on death affidavit that would avoid probate for your house. And these are all fine and dandy, but truthfully, it does not work. And that is one, because people get money outright. They don't get it in trust. That's a huge deal. But as important is, let's say you have 3 kids and one of them passes away. Well, if you have a beneficiary designation, it goes to the 2 living, not to the kids of the deceased. So, in a trust, there's a lot more planning that can be done in case of what happens if one of the children passes away. What happens if, you know, uh, somebody becomes incapacitated or disabled. Those things become so important in a revocable living trust, right? And it's flexible.
yeah, it
Flexible,
is.
you can amend it, revoke it, right? You can make changes anytime you want. It's a beautiful thing.
Yeah, it's fully flexible, fully changeable. As you said, when you don't do so, it takes you back to the idea of this is estate planning, right? It's not about
Right,
estate documents. Because
right,
with documents like getting a beneficiary designation signed on your bank account or a transfer on death at the stock brokerage account that you have, or even do a transfer on death deed, like you
yeah,
said, it goes from A to B. Once B gets it, it's in their name, and all the problems that they may have are attendant to their receipt of that property. So, like if they owe money to somebody, there's a creditor issue. If
Yeah,
they're, about to get divorced, there's a divorce issue. If you are concerned and love your family, like you said, you
yeah,
don't give them the things outright. What if
right,
you have the beneficiary designation and the person who's getting that passed away? It's coming into your estate. What if
right,
you name the beneficiary of your child and your child is 9 years old? What's the 9-year-old going to do with that? So there was
right.
it without planning to say this will go into a trust to be controlled by the person that I choose to have it controlled. Outside of the auspices of the court, you keep the whole guardianship issue out of
Yes,
play.
yes. Well, and in Ohio, on those transfer on death deeds, you have to have a spouse sign off their dower rights. So we had a case where we had 6 kids and they inherited this property under a transfer on death deed, and one of them was getting a divorce. And
Mhm.
guess who said I won't sign a thing? The
Mhm.
ex-spouse, right? Or
Right.
soon to be
Soon to be.
ex-spouse.
Right.
Yeah. And
Yeah.
so it held up the property sale for 3 years. I mean, it just, it's an ugly thing. A trust in general, whether it's revocable or irrevocable, can help with a lot of those issues.
Absolutely. And
Yeah,
again, everything is not for everybody at all points of everyone's life, right? You're
correct.
starting out in life, you're going away to school, or your parents are concerned they want to get some documents done, or you should get some documents, or you're a young couple. Then a will plan is fine. It's a will plan is a fine thing at that point in your life when you're really not don't have assets, not really concerned about that, but you do have concerns that you need certain things. You need a
Right,
healthcare proxy, or you need a good power of attorney. We've spoken about those in the prior episodes. And that will is not a bad thing for someone who's not doesn't have any complexity really in the assets they own, or not significant complexity. And as you get more boxes, as you get more assets and things that you have to get, that is a good time to think about getting the revocable living trust. And then we'll talk about the next steps after that, which is generally getting some kind of asset protection if you have some kind of career that presents some risks and you want to protect at least some of your property. If you're a business owner and you want to protect some of your issues and some of your property and some of the things you own, then you may think about doing some asset protection planning. And if you're concerned and you're getting older about long-term care costs, that's when we talk about using irrevocable trust, asset protection trusts, to help either avoid taxes or help avoid long-term care or other things, which we'll be talking about in future episodes. So I think that we kind of knocked it out of the park. I think that everybody who's listening should have some idea
oh
why we
yeah.
want to get a revocable trust or a little red wagon.
Well,
That's what we call it.
and a little plug for us, by the way, because I want you to know our process. Our process is to do a vision meeting, which is just figuring out what you need. Next step is design, and that's creating this plan and us asking you a bunch of questions. But the third part is also important, and that is funding. And so both Andrew and I, focus on all three of those. And because we do that, I think it puts us a step above. And I don't want to give the proverbial pat on the back, but how many times do we see trusts that have nothing in them? And so
I'll pat your
funding
back.
becomes, yes, thank you. Thank you. Yeah. So how many times do we see it? It just, you have a plan that doesn't work. It happens all the time. So
It does. And things
anyway,
change in life.
that's
Things
right.
change in life. And if you don't, like I see so many wills that are 20 to 30 to 40 years old, and the average time between someone does a will and comes back and looks is 19.7 years.
Wow. That's
So think
crazy.
about how many things change in 20 years.
Yes.
And so you need to have some kind of attachment to your estate planning and be mindful that the things that happen, whether it's in your life or it's outside of your life happening to you, you have to
Right.
be mindful and think about staying on top of it at least every few years. But we offer a
Yes.
maintenance program in my office. I know you offer one too. You want to
Yes.
explain a little bit what a maintenance program is?
Well, it's optional, right? We have to make sure everybody understands it's
That's
optional,
true.
but
Yep.
we have about 86% of our clients on maintenance. And maintenance is an annual fee for you to get unlimited access to us, to get any changes, anything you can think of done in this plan. We also do some social events. We have some monthly maintenance meetings, which talk about things about trustees and placing people. And we just had one on senior scams and how can you avoid the scams, which was really well attended. So maintenance has its place. And for most people, it does make sense. But again, it's optional and you get to choose whether it's right for you or not.
Yeah, but it's a good thing because it keeps you closer to the fact that these documents, which control the most important things in your life,
Yes.
right? The most important things are not things. Those are your family members who you love and who you're going to give your things to. But
Right.
this helps you control the things in your life in the most optimal way. It doesn't work in its most optimal level if you don't keep track of the things that change and make those changes for you.
Yes.
So
Yes. Well, good. I really thank you, Andrew. I thought this was a really good episode, and I'm excited for the future. What are we talking about coming up?
next time we're going to go through irrevocable trust. We're going to
Oh,
talk
good.
about why we use them, what they are, some of the different types of them probably, and then we're going to we would love some feedback. You can reach me at info@epelg.com. That's the Estate Planning and Elder Law Group in Queens, New York.
And you can reach me at info@icanprotect.com. That's info@icanprotect.com.
And we definitely welcome your suggestions for topics
Yes.
for this podcast. It would be really great for you to tell us, "Oh, I love what you said. Can you say more about this, or can you elaborate on something else completely, entirely different?" So,
Right. If not, we're just going to get into recipes. So we better get some feedback.
well, I just cooked a great brisket this past weekend. I'm happy to give you the recipe.
Awesome. I love it.
Now I know what I'm bringing to my next potluck.
Yes. Yes.
Yeah. Well,
Excellent.
thank you so much, Matt. And
Thank
it's
you, Andrew.
great. We'll see you soon.
All righty.
Bye.
Bye.